I paid $750 cash, full amount of the bail.
The problem is yeah, we could apply the 325 and then refund the balance to it, but that has to be done with the permission of whoever posted the bail. Where did who actually came up with the money?
It was my money, Your Honor. And I
paid by somebody else.
Correct. Yeah, I brought it in and paid by somebody else. Yeah.
That is why we have to have them approve of this.
Okay.
I've seen way too many disputes between whose money it was.
Okay. Okay.
I can't refund or apply somebody else's money that somebody else paid.
So how do they go about coming down and getting that taken care of?
What they need to do is come to the counter.
Okay.
And give permission to us to
okay,
apply enough of your money to take care of the fine.
I can have that done today.
And if that can be done today, that'd be great.
Absolutely.
I don't know how quickly. We have court all day, so I don't know if anything can be accomplished. But once the person does come up and give permission to pay the money towards the fine and refund the rest to him. And of course, it'll be up to you to get, if it's your money, to get it back from whoever posted it.
Because then I believe,
of course, this is.
I also had the $150 fine, I believe, for the DWLS on 3rd. I was here on the 12th, I believe.
That would not be a part of this.
Okay, so I guess if I pay both of those with that, am I taken care of here with you guys?
It might be. Could the both of you come in together? Whoever posted the
yeah,
money?
absolutely.
Why don't we do it that way?
Okay.
Why don't we give you another provisional court date?
Okay.
October 24th. And if this is taken care of by the October 24th, well, it's really up to the city to give you the benefit of the bargain, or.
Yeah, why don't we, I mean, if you think you can get taken care of quickly, just reset for 2 weeks.
That we can do. Mr. Schneider, the city is, I don't know how well things are going for you right now. It says that you've had other charges since then. I hope things are improving.
They are, Your Honor.
I'm glad you're here, you're dealing with this. That's always a good sign. Mr. Schneider, if you bring in your person and say, hey, we want to take care of whatever money we owe the city of Yelm, the prosecutor is willing to give you the benefit of the bargain and dismiss the theft charge.
Thank you.
Understood?
Understood.
Mr. Schneider, good luck to you. Take care. And once again, yeah, I've seen all kinds of problems arise from money, bond money posted, and
right.
Hearings have to be held as to who the money actually belongs to. I don't want to get the court in that position. Yeah. But thank you for appearing. I think we know how to resolve the matter now. Thank you. We'll reset the matter out to is October 10th. Can you get it taken care of? By then, if not today?
Absolutely.
October 10th is Mr. Schneider, that is the date. We'll do we need a date for Mr. Schneider? Craig Schneider. everything is on the, O-Court system now, and sometimes, there, bingo. Got it. And of course, I'm a cyber dinosaur. I have to rely on people that know a lot more about this than I do to,
Absolutely.
yep, it certainly does. Mr. Schneider, I want you to go to the window, get a copy of today's order, and again, that this is all taken care of by your next court date. You don't need to show up and wait to talk. Any questions at all?
That's it.
You take care of yourself.
Thank you, Your Honor.
Thank you. Daryl Turner does not answer. We do have somebody up there. I called through the calendar, but we'll try again. Alicia Christensen. Good afternoon, ma'am. How are you? This looks like one of these SOCs that looks like the only problem is money. $250 is owing, and there haven't been any new violations. What would you like to tell me?
I got a letter from my doctor. It's just I've been mental treatment, had traumatic brain injury, so I actually forgot that this was pending. It got kind of on the side. It just got out of my brain. So I didn't have money at the time. I just now got on Social Security. So I'm able to now make payments on it if that's possible. At the time I didn't have any money, and it,
How are you doing now?
I mean, I'm staying out of trouble.
That's the important thing.
Yeah, I'm receiving mental, I got a Greater Lakes PAC team is working with me, so I have doctors and counselors and everything, daily basis.
That is great. Mr. Raphael, would you like to see the letter?
And like the financial thing is I'm just now able to start maybe making payments on it. My disability just came through, and so I have some income now.
Sounds well. And you have a little help there with you. It's always good to have.
Yeah, always, yeah, that help our system.
Anything you want to say on behalf of Ms. Christensen?
She's in crisis right now. Okay.
Okay. Did he have a position, which he's asking for his time to take care of the? Christensen, how about we do this? We'll sign an order. So it's $250. Can you handle like say 25 a month?
Yes,
Would that work?
yeah, I can do that.
Let's do it that way. You can pay it that the first payment due in October. So that's give you a little time. Are you able to make? Is that going to work?
Yes,
I'm not going to give you a new court date. I'm going to sign an order to the effect that you can take care of that at 25 a month. I want you to take care of your health and yourself before you take care of this.
right.
This is something we can work out with. If for some reason you can't make a payment, I want you to let your assistants, let your help know that you're not able to, and just let us know what's going on. And as long as we're apprised, brought up to date on what's going on with you, it's all going to work out. It's, without any problem at all. I want you to take care of yourself first.
Yes, sir.
First payment would be due October 26th. So, and that's $25 a month. Now, a time payment agreement has been prepared. And what I want you to do is get a copy of that at the window outside the courtroom and to your left, and look it over carefully. And again, as long as we know what's going on, this is all going to work out just fine.
Okay,
Okay?
all right. Stay in touch, like if there's not a payment, like if I can't make a payment, just stay in touch and let you guys know that.
What I want you to do is stay in touch with, not us, but with your help.
Okay.
They'll make sure that we're notified, I'm sure, of any changes in your situation.
Okay.
Christensen, I'm going to wish you the best of luck. You take care of yourself. That concludes the hearing, and again, you take care of yourself.
I appreciate it.
Good
Thank
to see
sir.
you. You take care.
All right. Yeah, thank you.
Thank you, man. Appreciate your help. Take care.
And you said checking out that.
At the window, they'll give you a copy of the time pay agreement,
Okay.
so you'll have that.
Okay, thank you very much.
Thank you, ma'am. Take care. Oh. He just showed up now. Well, we now have Mr. Rigers. Good morning, Mr. Rigers. Are you able to hear me?
Yes, sir.
It's now quite a bit past the half hour past the your hearing time. Your attorney did appear, and you hadn't been in contact with him.
Yeah, unfortunately, I haven't been able to check my personal email on my phone. I was working on my work. I've been working off my work phone, and he just texted me this morning. I got it a little bit late.
City have a position. I'm inclined to, out of courtesy to Mr. Narrowlack to. I'll defer to the city.
Yeah, without counsel.
Mr. Rigers, in your absence, I did issue a warrant or order a warrant. It's not issued for your arrest. I'm going to cancel that. I'm going to give you another court date, and that is going to be October 10th. I'm going to reset it for that. We'll send Mr. Narrowlack a copy of the order, and we'll send you a copy of that as well. But I'm going to urge you to immediately contact Mr. Narrowlack and tell him what's the status of the matter is. We'll send him a copy of the order, but you need to be in touch, okay?
Absolutely.
Mr. Rigers, thank you for appearing. Better late than never, but yeah, immediately get in touch with Mr. Narrowlack, okay?
Appreciated, Your Honor.
Take care.
You too.
There we are. Hello? Oh, he'll talk to us in a second.
Good morning, Mr. Haverco.
Good morning, Your Honor. This is Daniel Lenz. He comes on before the court this morning on a couple of cases for arraignment.
Mr. Lenz, good morning. Full name Daniel Joseph Lenz.
Good morning. That's me.
Matter is set for arraignment at this time. However, I'm going to turn to Mr. Averco for.
Yeah, yeah, thank you, Your Honor. He'd like, court-appointed counsel, and pursuant to that, I, was able to contact Mr. Lenz yesterday, and I had a copy of the, police reports as to both matters, was able to review those with him. We also had a discussion about what an arraignment is, to be read the charges in open court and the maximums that could be imposed, the elements that the city would have to prove, and he has the right to do that. Notwithstanding that, it's his choice, I believe, to waive arraignment and proceed with a plea, and pursuant to that, I reviewed with him a statement of defendant on plea of guilty to indecent exposure. In exchange for that plea, the city, as part of the agreement, would move to dismiss the criminal trespass case. I also reviewed with him different ways to enter a plea, either a straight plea where one admits the facts that support the charge. We also discussed something called an Alford plea. I believe it's his intention to enter an Alford plea. He is choosing not to openly admit guilt, but would agree that if the matter were to proceed to a trial and a fact finder, whether it be a jury or judge, that if the city's evidence was presented along with any evidence available to Mr. Lenz, he believes it's highly likely that a finder of fact would enter a finding of guilt, and pursuant to that, he wishes to enter a plea. In addition, he also wants to take advantage of the city's plea offer, which is no additional jail time, and again, a dismissal of the criminal trespass charge. And with that, I'll turn it over to you, Your Honor.
Did you have anything to add? No. Again, for the record, is your full name Daniel Joseph Lenz?
Yes, that's me. That's correct, Your Honor.
With anything Mr. Haverco just said on your behalf, I am appointing him to represent you in this matter. You disagree with anything he told me?
No.
I'm looking at a statement of defendant on plea of guilty to one count of indecent exposure, which also references a dismissal of a criminal trespass, second-degree charge. Have you gone over the plea process with Mr. Haverco?
Yes.
Did he answer any questions you might have as to what it meant to enter a plea of guilty to a criminal offense?
Okay. He asked if I answered your questions about pleading guilty. Yeah, he did.
If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no witnesses, no appeal if things go against you here. And I'd be free to impose whatever sentence I thought most appropriate, up to the maximum, which would be 90 days in jail, $1,000 fine, regardless of what's recommended. You realize that?
Yes.
And I believe you've also gone over the police reports and decided to enter the plea, believing that if the matter were to go to trial, things could go badly for you, and you want to take advantage of the plea bargain Mr. Haverco has worked out for you on your behalf.
Yes, sir.
With that in mind, as to one count of indecent exposure alleged to have occurred within the city of Yelm on September 1, 2024, how do you plead guilty or not guilty?
Guilty.
Take that plea of your own free will.
I plead guilty.
Anybody make any threats or promises to you to make you plead guilty?
Did anybody threaten you? Nobody threatened me.
I'll find the plea to be freely, knowingly, and voluntarily made, and I am familiar with the probable cause statement, and I do find there is a sufficient factual basis upon which I can accept the plea. Mr. Haverco, anything further with regard to the sentence?
Nothing to add. Ask the court to follow it. He's a homeless individual. He's indigent. based on that, the city was not asking for any financial obligations. He wouldn't have any ability to pay. Asked the court to follow that.
City, yeah, Mr. Redfield. Mr. Lenz, anything you'd like to tell me? You don't have to say anything, but if you want me to know anything, about the.
No, I don't.
I'll take that as a no. I am gonna follow the recommendation, 90 days in jail, all suspended on the condition you have law-abiding behavior. That's, and, dismissing the, criminal trespass second degree, the charge of, August 27th. Mr. Lenz, this isn't the first time, I've seen you. I'm certainly hoping it will be the last, but that's not up to me. That's up to you.
Understood.
Stay out of custody by obeying the law, and that includes not exposing yourself to the public with the intent to
Okay.
stay away from places from which you've been trespassed. Okay. You have a good day. That concludes the matter. You'll be released today unless there's some other hold on you, which I don't think there is. Take care of yourself. Okay.
Okay. Thank you, Your Honor.
Thank you, Mr. Everett.
You'll do that today. He is done.
Mr. French, how are you? Sir, absolutely. Absolutely, if the parties are ready. We're now back on record. Morning, sir. Full name Travis James Stewart.
Sir.
Stewart, good morning. Matter set for a pretrial. I'll defer to Mr. French for the status of them.
Yep, Your Honor.
October 10th, the 24th, Next two dates are the 10th and 24th of October.
I have a First County.
24th,
That would be fine.
9 a.m. You bet. We're resetting the matter to October 24th. Stay in touch with your attorney, and any conditions of release earlier set remain in effect, of course.
Yep.
As soon as I have a notice of hearing has been set, prepared. You can get a copy of that at the window outside the courtroom and to your left. October 24th, 9 a.m.
Thank you, Your Honor.
Thank you, Mr. Stewart. Mr. French? Hearing no objection, no problem. Certainly. City have any objection? Illinois, yes, we're not gonna drag him back here from Chicago to same court date, 24th.
Yeah, why don't we
Nice.
stick with
And yeah, got a notice of hearing, and again, that can be got at the, I don't know that we do. Perfect. Mr. French, good to see you as well. Convey our greetings to Ms. Bowden when you next see her. You take care. Have a good day. Welcome to fall. Catnorn is on.
Oh, Your Honor.
Good morning, Mr. Van Acton. We'll address your
I
matter.
apologize for not being there in person. I am currently in day 4 of quarantine, having tested positive for COVID, shingles, and a staph infection. So I figured I should take it serious this time. But I'm here for 2 clients. One is Ben McLeod. Who I'm surprised isn't there yet. He was well aware of today's hearing and had actually confused it a couple of times, showing up without me, thinking that it was earlier than it was. So I'm surprised, but I do think I can waive his presence for today's hearing, as we're asking to set this one for trial.
Bradfield,
Do you need a case number for that?
I'm sorry to hear that's, how are you doing? How are you?
I'm feeling pretty good now. I had this was my first bout of COVID, and this the shingles and staph infection didn't help. But I had a couple of days of rolling fatigue and shivers and shakes. I feel pretty good now, but I'm not allowed. I'm still contagious, and as Your Honor knows, I work for the Puyallup tribe, and there's a history of people bringing illnesses onto reservations that I don't want to be a part of. So I'm taking it seriously, and I'm up in my attic and doing what I can from where I am.
May it be your last. May it be your last. How far out do we want to go?
Well, my understanding is that they conduct trials in this court once a month, correct?
The next available dates are October 10th, October 24th. So make
October
sure
24th. Let's if we could do a trial that day would be good.
is resetting the pretrial for the 24th.
Was that a pre-trial you said, or not the trial date?
You want a trial or a pretrial? I'm not hearing that's. You want to set the matter for a bench trial or
Jury trial, Your Honor.
jury trial? Have you discussed this at all with what this would involve? If you're asking for a jury trial, we don't conduct them here. The case is transferred to Thurston County District Court, and the jury trial would take place up there. Is perhaps this is something you might want to discuss with Mr. Ratfield?
Sure. I can do a short pre-trial set over then. I think you offered October 10th. I'm not sure I have Mr. Atfield's contact information. I have reviewed the police report and based purely on the police report, believe that this is going to go in my client's favor at trial. But I will be happy to discuss that with the city if we want to set a short set over.
I would set it over to October 10th. Yeah, given the logistics involved, the refiling the matter, et cetera, I prefer the parties to exhaust attempts to resolve the matter. Without contact information, of course, you can't very well do that with Mr. Ratfield. I'll make sure that you get his contact information.
Did you say October 5th, Your Honor?
October 10th.
It's October 10th. Okay.
October 10th, 9 a.m.
Okay.
You have one other matter on the calendar, and that is
Kinsey DeFord, Your Honor. And I'm sad to report, Your Honor, that Mr. DeFord has appeared to have a subsequent relapse, and I have no information as to his whereabouts at the moment. The tribe made extensive efforts to get him to go back into treatment, and we have not been successful. And we've presently discontinued his housing voucher if he's not willing to take the treatment seriously. So, as Your Honor knows, sobriety is more of a direction than a destination. It's something that you've got to choose to walk towards every single day. And the moment you abandon that choice, you start all over from square one. And I think that's where we are with him. I don't have reliable contact information with him, but I do have a last known phone number and made him aware of today's court hearing. I wish I had better information for Your Honor.
we could. I'm very mindful of the issues facing Ms. DeFord and people in her situation. What I'd be inclined to do here, I'll hear from the city, is reset the matter, note the non-appearance for speedy trial purposes, and give you a chance to make contact with her. Would that be acceptable to bump it over to?
Certainly would appreciate that, Your Honor. Yes.
City have any objection? No. That's what we'll do then. We'll reset it to October 10th. Send a notice to yourself and her, and hope that you can reestablish contact and get her. And I fully agree. There's a lot of speed bumps on that road to sobriety. You're right. It's not a destination. It's a road, and a bumpy one at times.
Yeah.
That concludes the hearing. Mr. Van Ecton, I'm gonna wish you the full recovery from the ravages of COVID, and I'm hoping it's your first and last experience. I've had one, and hope I never have another as well. Take care of yourself.
Thank you, Your Honor. And I will be speaking with the city's attorney directly. Thank you.
Hey, thanks much. DeBrio, on. Morning, we're going to call the matter of Tomas Monte Rivera, docket number 8. Do you have an attorney present? Are you able to hear me?
I am, Your Honor. Good morning. How are you?
So far, so good. Yourself?
I'm doing well, Your Honor.
Call your matter now. Your client has been cited for DWS second degree, I believe. Matter set for a pretrial. I'll defer to the parties for the status of the matter.
Correct, Your Honor. I did fill out a motion to continue in O Court. We're asking the court to set this matter over to the pretrial on October 24th. Mr. Rivera is in the process of getting relicensed. I just need a little bit more time for him to do that.
Hearing no objection from the city, I'm citing electronically an order resetting the matter to the 24th. And again, yeah, relicensing, that's where only thing we're really interested in here. We'll send a copy of of today's order to yourself and to Mr. Rivera.
I appreciate it, Your Honor. Thank you.
Take care. Good luck.
You as well.
Mr. Cadnorn, good morning. How are you?
Good morning, Your Honor. I'm well. How are you?
So far, so good, but it's early.
Your Honor, I'm here on 3 matters today for my firm. The first one is mine, and that is Miss Allison Connor.
I'm looking at O Courts. I see a motion to reset that matter to November 7th. Is that correct?
Yes, Your Honor. I'm working with Miss Connor on, she's starting IOP actually tomorrow. We have regular communication. I'm hoping once that happens, I'll be able to work out a global with the city. I'm headed out of town on a little bit of vacation in October, so that's why I selected November 7th date.
Hearing no objection from the city, I'm signing an order resetting the matter to November 7th. Mr. Cadnard will send you, as well as your client, a copy of today's order.
Great, thank you. My next matter is for Mr. Lewis Brandon Donahue.
Brandon Donahue, call that matter now. I'm looking at O Courts. I see a request to set the matter over.
Yes, sir, that's correct. Mr. Lewis is currently in trial. I believe he needs additional time to speak with the city. This is a defense motion to continue and with the speedy waiver included.
Hearing no objection from the city, resetting the matter to October 24th, 9 a.m. Electronically signing the order as we speak.
Thank you. And my final matter is Jason Turner for Mr. Taninga.
Got that matter, pulling it up. I likewise note there's a motion to continue the matter to October 24th, 9 a.m. on behalf of Mr. Turner.
Yes, sir. Thank you. Mr. Taninga is out ill today. He was going to hopefully be here to work on a resolution, but he'll be in touch with the city's prosecutor.
And of course, you're in touch with your clients,
Yes, Mr. Cheney spoke with them. Yes.
signing the order as we speak. And once again, a copy of that order will be sent to your client and to yourself, Mr. Kattenhorn.
Great.
We've concluded the.
Thank you. Have a great day. Bye-bye.
You as well. Good to talk to you. Take care. We're missing Charles Johnson. I think that's the only one. Huh. Ma'am, you're here for the pardon? Correct. Mr. French handled it. It was. Now back on record, I'm going to defer to the parties for the order in which cases are called.
Okay, thank you, Your Honor. We could first turn to the 9:45 calendar, item number 4. Beside Mr. Tuatu, which matter comes on for the court on the warrant wash calendar. We do have a disposition on the matter. He's going to enter a straight
Good morning,
plea
sir.
to the charge, and so we're going to treat this today as a pretrial. I'm going to have him sign the form.
For the record, is your full name Nayeli Tuatu?
Yes, sir.
If I mispronounce your name, sir, I apologize.
So we've just signed and placed into Oak Court's statement of defendant plea of guilty. Again, he's going to enter a plea to the charge. City's recommendation is going to be all suspended time, all suspended for 12 months on the condition, no new criminal law violations, and pay a $250 court fee, at the end of which time the case can be closed.
Good afternoon, sir. If I mispronounce your name, for your full name, Nayeli Tuatu. I apologize. I'm looking at a statement of defendant on plea of guilty to one count of violating a no contact order. Plea form tells me you're 41 years of age. Any problem at all reading through, understanding the plea form with Mr. Haverco?
Oh, yeah.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 364 days in jail and up to a $5,000 fine, regardless of what's recommended by the parties. You realize that. With that in mind, is to one count of violating the terms and conditions of a no contact order within the city of Yelm on December 28th, 2018. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty?
Oh, yeah.
I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. City, have anything to add to the recommendation? Mr. Haverco,
Nothing to add, Your Honor.
you have a right to tell me anything you want. You don't have to say anything, but if you want me to know anything about the situation, now's the time.
Pretty clear.
I'm going to follow the recommendation, 364 days in jail, all suspended on the condition you have a law-abiding behavior and pay a $250 probation monitoring fee. These no contact orders are something that needs to be abided by for as long as they're in effect, and unless they're modified by the court that originated the order. I'm reviewing the judgment and sentence. And we'll sign the same at this time.
I'll have the defendant sign. Does he just sign the
Ineligibility
order?
to, having accepted the plea, your right to have firearms is, until it's restored, that's gone until restored by a court of competent jurisdiction. Signing an order to that effect. So that concludes the matter. I'm going to wish you the best of luck. What I want you to do is go to the window outside the courtroom and to your left. You'll get a copy of today's orders. I want you to look those over, read them, and if you have any questions, give Mr. Haverco a call. I'm going to wish you the best of luck. If that order is still in effect, you need to abide by it until it's no longer in effect. Good luck to you and take care. Thank you for appearing.
Turning to the 10 o'clock, item number 1, Brianna Barber.
Ms. Barber, good morning.
So what this is, we're proposing a participation agreement, and that is an 18-month stipulated order of continuance, what we call a slow reckless at the end of the 18-month period. The case will be amended to reckless driving. It's the DUI related fine and all of the DUI related conditions that are imposed. We are going to dismiss the suspended driving third degree count today. And we're also, with agreement of the city, we're moving to dismiss the infraction, item number 2. So that's to be dismissed today. And I've reviewed it with her and all the conditions, and there's a lot of things she's got to do in a period of time, but evaluation and all that kind of stuff. And I've gone over that with her.
For the record, is your full name Brianna Lee Barber? That's it. Do you disagree at all with anything that Mr. Haverko just said? An SOC stipulated order of continuance is in reality a contract between yourself and the city, under the terms of which this charge can be reduced from a DUI to a reckless driving 18 months from now, if you comply with all the conditions set forth in the agreement. Mr. Haverko touched on them. To me, the most important part of it is getting the drug and alcohol evaluation and complying with any recommended treatment. If there's any sort of an issue here or problem here, we want to deal with it so it never happens again. A DUI conviction is much worse in terms of impact on your life than a lot of felony convictions, and I don't want to go there. In return for the agreement, though, you've given up your right to go to trial, have witnesses about the case. If there's a violation and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction. You don't want to go there. You want to take advantage of the agreement and get the charge reduced to a much less serious charge. And of course, the reason why it's as serious as it is the number of people we kill, injure on the highways every year. Ms. Barber, all I can do is wish you the best of luck. Hopefully this will be a learning experience and one that'll never be repeated. Any question at all? Now, the SOC, that's kind of a lengthy agreement. The costs are $990.50, the same as if it was a DUI. I want you to read over the document very carefully, and if you have any questions at all about what it means, give Mr. Haverko a call with your questions. Don't let them lie. Any questions of me?
Oh, thanks for bringing that up. Yeah,
That's-
that was an issue. The court had imposed a pretrial interlock device requirement, and I indicated to Ms. Barber that the court would likely remove that requirement upon disposition of the case today.
I will.
Thanks for bringing. Sorry about that.
I would just, that's not a condition of the agreement, and therefore I haven't said anything about that. But that does, any pretrial conditions evaporate with the entry of a disposition of the case. So you can remove that, but I'm just hoping, beyond hope, that you don't need it for any reason at all. If that's drinking and driving are things, activities that need to be completely separate from one another. Ms. Barber, I'm going to wish you the best of luck. You take care of yourself, okay?
Good luck. Ms. Frost? So this is Tammy Frost. Matter comes on before the court for a pretrial hearing on a suspended driving first-degree case. Parties have reached an agreement. That being, she's going to enter a straight plea to the lesser charge amended to a driving while license suspended in the second degree. The recommendation is going to be 364 days in jail, all suspended for 12 months to never be imposed, so long as during the next 12 months she has no new criminal law violations, and pays a $250 court fee, at the end of which time the case can be closed.
Ms. Frost, we are not strangers, but I need for the record to confirm that your full name is Tammy Marie Frost. Ms. Frost, I'm looking at a statement of defendant on plea of guilty to one count of driving a license suspended or revoked in the second degree, amended down from first degree. Plea form tells me you're 64 years of age. Have you gone over the plea form with Mr. Haverco? And if you had any questions about what it meant to plead guilty to a criminal offense, were any questions you had answered? You'll get the chance. You're gonna have that chance. First things first. Now, if I accept the plea, I would be free to impose up to 364 days in jail and up to a $5,000 fine, this being a gross misdemeanor. Likewise, you've given up the rights contained in paragraph 5, no trial, no appeal, just simply a sentencing. With that in mind, as to one count of driving a license suspended or revoked within the city of Yelm on July 29th, 2024, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11, that does satisfy the factual elements. Now, you have a right to tell me anything you want regarding the matter now. So now's the time to. I accept that, and that may well be the city's amended the charge. But keep in mind that the first degree is that bears some pretty significant mandatory jail time on conviction. You don't want to go there. You're very fortunate to have a chauffeur, so to speak, that do your driving for you. And that I hope you're appreciative of the burden that places on her to be responsible for you. That's at some point, you know, you want to get relicensed, and one way to do that is to just make sure you don't get cited for any violations here in the future. I'm going to sign on the judgment and sentence on Ms. Frost and wish her the best of luck. I am hoping that you don't get another one of these. That's enough is enough. And it just keeps adding on to the suspension. Not a good idea. I'm signing in open court the judgment and sentence. I want you to get a copy of that at the window outside the courtroom to your left. Look it over carefully. And as I say, call Mr. Haverco if you have any questions about what it means. Good luck to you. Any questions of me? Take care of yourself. Ms. Frost, you are indeed fortunate. Good luck to you.
Good luck. Yeah, just go through the first window. Yeah. Jack Hood.
Morning, sir. For the record, is your name Jack Julian Hood?
Matter comes on before the court for a pretrial hearing on a theft third-degree charge. Parties have an agreement. He's going to enter a straight plea to the charge. The sentencing recommendation is going to be 364 days in jail, all suspended for 12 months on the condition no new criminal law violations, $250 court fee, at the end of which time the case can be closed.
Do you disagree with anything at all Mr. Haverco just said on your behalf? Sure. Do you disagree with Mr. Haverco at all about anything he just said? I'm looking on the screen at a statement of defendant on plea of guilty to one count of theft in the third degree. Plea form tells me you're 18 years of age. Any problem at all going through the plea process with your attorney?
No, Your Honor.
Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. Simply the sentencing, which, this being a gross misdemeanor, could be up to 364 days in jail and or a $5,000 fine. With that in mind, as to one count of theft in the third degree, alleged to have occurred within the city of Yelm on August 22nd, 2024, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Heard the recommendation of the city and your attorney. Is there anything at all you'd like to add, Mr. Haverco?
Nothing, just no, Your Honor, to ask the court to follow the recommendation.
Mr. Redfield, anything to add? Mr. Hood, you have a right to tell me anything you want. You don't have to say anything, but if you have anything to you want me to know, now is the time. What I'm hoping is this has been a learning experience and one that will not be repeated. I'm going to follow the recommendation 364 suspended on the condition you have law-abiding behavior and pay a $250 probation monitoring fee. Now, the most important thing to me is stay out of trouble. Learn from this. We all make mistakes. We all do things we shouldn't do. The thing is that you're human. Go on to make new mistakes. Don't repeat old ones. Any question at all? Taking me a little bit of time to monitor, to go to from one screen to another. But I've now done that, and I'm now signing the judgment and sentence in open court. And as you may have heard me say a little bit ago, I want you to go to the counter outside the courtroom to the left, get a copy of today's paperwork and look it over. And if you have any question at all, give Mr. Haverco a call. I wish you the best of luck. You take care of yourself and have a good life.
Thank you, Your Honor. Next matter, Sydney St. Marie, item number 10 on the 10 o'clock calendar.
Good afternoon, ma'am.
Go ahead and sign it here. She's going to, we have a resolution. She is going to enter a straight plea to count 2 ignition interlock device violation. Upon the court's acceptance of the plea, city will move to dismiss count one, suspended driving third as part of the agreement. Sentencing recommendation is a year in jail, 364 days in jail, all suspended for 12 months, to not be imposed so long as she has no criminal law violations and pays a $250 court fee. It can be closed after that period.
Good afternoon, ma'am. Is your full name Sydney Christine St. Marie? Ms. St. Marie, I am looking at a statement of defendant on plea of guilty to one count of operating a motor vehicle without ignition interlock when required to have that by the state of Washington. Plea also references a dismissal of the DWS third charge. Have you gone over the plea process with your attorney? And if you had any questions about what it meant to plead to a criminal charge, was any question you had answered? And any questions of me about what it means? This is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'd be free to impose that regardless of what's recommended. You realize that. You also give up the rights contained in paragraph 5, no trial, no appeal, no witnesses, simply that sentencing. With that in mind, as to one count of operating a motor vehicle without ignition interlock on August 5th, 2024, within the city of Yelm, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. Yeah, okay. We're now reviewing the judgment and sentence, signing off on that. The $250 monitoring fee, that can be paid at the rate of $25 a month. Have any issues making the fine payments, let us know, okay? Any question at all? With good driving, these requirements, ignition interlock, et cetera, they drop off in time. So just drive carefully and get your license reinstated, and you have a good day. Yes, go to the window and thank you, ma'am. Good morning. Get back to that screen.
For the record, Christopher Taylor on behalf of Mr. Newcomer. Your Honor, this is set for a pretrial on a criminal trespass second-degree charge. I am asking for a jury trial date.
Pardon?
I'm asking for a jury trial.
We'll do that. Involves refiling the matter in Thurston County District Court. We don't have jury trials here.
Yes, yeah.
What we'll be doing is sending refiling the matter there, and the court will advise you of two confirmed date and a trial date.
Yes, Your Honor. Thank you. I don't think we have anything else we need to discuss.
Not unless the parties have something to present, I believe not.
Okay. Thank you, Your Honor.
Have a good day.
Yes. So we have the interpreter here now, so let's go ahead and take that out of there.
Once again, I'll defer to the parties.
Yep. So that would be, that would be Mr. Jordy Cisneros Chavez. That's item numbers 3 and 4 on the 11 o'clock calendar.
Got it.
Your Honor.
Good morning, Mr. Mold. Do you solemnly swear or affirm that you will accurately transcribe from Spanish to English and English to Spanish, all that is spoken here? Okay, thank you. Good morning, sir. Is your full name Jordy A. Cisneros Chavez? Yes.
We need to have them signed. Interpreter's signature as well. There's a spot for you to sign. Okay. So the parties have reached an agreement on the DUI, and it is anticipated that he is going to enter a plea to the reduced charge of negligent driving in the first degree. The plea is also by way of an Alford plea. And I've gone over what that is with him, with the assistance of the interpreter. The basis of it is it would be in dispute what level of marijuana was in a system. And there's factual issues, but in the interest of settling the case, and because it's of a great benefit to the defendant, he's choosing to enter a plea to the lesser charge.
City, have anything to add? Good morning, sir. I'm looking at a statement of defendant on plea of guilty to 1 count of negligent driving, first degree. Amended down from a charge of driving while intoxicated. The maximum penalty would be 90 days in jail and or $1,000 fine, which I would be free to impose regardless of what's recommended. You likewise give up the rights in paragraph 5. With regard to a amended charge of neg 1 in Yelm on July 19th, 2024. How do you plead guilty or not guilty? Negligent driving. You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made. And pursuant to the case of State v. Alford. Which means you reviewed the police reports, discuss the matter with your attorney, and want to take advantage of the plea bargain. Is that correct? I have a recommendation as to sentence. You can tell me anything you wish for me to know. You don't have to say anything. To talk to me, say anything. Okay. Mr. Travico, anything further?
Nothing to add, Your Honor.
Mr. Ratfield? I'll follow the recommendation. 90 days suspended. $990.50 fine. Suspended jail time on the condition of law-abiding behavior. This would count as a prior DUI conviction if there's a repeat. Very important to not drink and drive. Completely separate those activities. I'll sign the judgment and sentence. And I want you to go with Mr. Mould to the counter. Get a copy of the judgment and sentence, and if you have any questions. Was it through a bonding company? Yes, if the, it'll be refunded to the person that's, yeah, with the disposition today, the bond is exonerated. And that would be done, it would be returned to the person posting it. Can be picked up at the counter, but call first. Yeah, today is court all day. And, or it can be mailed, pardon? By mail, and that would go to Lopez, Correa, is here, on Joyce Court, in Yelm. Good address? That's where a check will go. Cisneros Sanchez, I want to wish you the best of luck. You take care of yourself and please don't repeat this. Thank you, sir. I take it the speeding ticket dismissed and the
Yes.
housekeeping. Need Mr. Mold back.
You don't need an interpreter. do you? Yeah, this is Jose Dorteo Ramirez Ruiz. He doesn't need an interpreter. Matter comes on, but this is item number 7 on the 11 o'clock calendar. Matter comes before the court for a protection order violation. Parties have reached an agreement. He's going to enter a straight plea. Well, actually not a straight plea.
Amendment.
He's making an Alford plea and also a plea pursuant to the doctrine as stated in the court case of In re Bar to disorderly conduct, because the facts don't meet the elements of disorderly conduct. So that's why he's doing that. For the background on this, Judge, there was an assault charge in Centralia Municipal Court. Maybe as part of a routine procedure there, they imposed a no contact order. It was rescinded 2 weeks later. And this occurred slightly before the rescission of that order. So really not out of legal principles, but I guess just out of equitable considerations, a party reached an agreement and he can plead this charge.
I'll accept it. Good morning, sir. Is your full name Jose Doroteo Ramirez Ruiz? I apologize for mispronouncing your name. Are you comfortable with the English language? I'm looking at a statement of defendant on plea of guilty to one count of disorderly conduct. Plea form tells me you're 39 years of age. Any problem at all going over the plea process with Mr. Haverco and understanding it? Now, disorderly conduct is a simple misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. I'd be free to impose that regardless of what's recommended. And you give up the rights contained in paragraph 5 if I accept the plea. No trial, no appeal, simply a sentencing. With that in mind, it's still one count of disorderly conduct alleged to have occurred within the city of Yelm on July 30th, 2024. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. And although the facts of the case do not really support a disorderly conduct, case law, In re Bar, and State v. Alford do allow me to accept the lesser plea given the equitable considerations Mr. Haverco eloquently stated. These things happen. It sounds like this is getting behind you, and I'm going to wish you the best of luck with that. I'll follow the recommendation, of course. 90 days, all suspended on the condition you stay out of trouble. 250 is recommended.
Yes.
Any issues making the fine payments so over time, let us know. We can certainly deal with that. Yep, same thing with the disposition today. That bail is exonerated. I haven't looked at the file to determine whether that was cash posted by yourself or a bail bond. Do you remember? Cash. That again, just like a moment ago, that'll either be can either be picked up at the counter or mailed out to. It has to go to whoever posted it. at the address we have.
Yeah, so once you get the money back. I don't know. How long does that take, Your Honor?
Due course of business, and it looks like the address we have is on Gold Street in Centralia. And it's to Max Hernandez Ramirez. We have to send it back to him. Is that a good address for him? And of course, if you want to pick it up here, and it would have to be him, and he would have to call ahead of time. Mr. Ramirez, I'm going to wish you the best of luck. You take care of yourself. I'm signing off on the judgment and sentence. And again, I want you to get a copy of that at the window outside the courtroom to your left. Look it over carefully and make sure you call Mr. Haverko if you have any questions. Any questions of me? Good luck to you. Take care of yourself.
Next matter would be item number 8, Jacqueline Rostran Martinez on the 11 o'clock calendar.
Any shot?
I have to say. The matter comes on for a pretrial hearing on a suspended driving third-degree charge, ignition interlock device violation. Parties have reached an agreement. She's going to enter a straight plea to the ignition interlock device violation. Upon the court's acceptance of the plea, city will move to dismiss count 1, suspended driving. Recommendation to be all suspended time, 12 months. The condition she pay a $250 probation fee, a court fee. And at the end of which time the case can be closed.
Good morning, ma'am. For the record, is your full name Jacqueline Rostran Martinez? I'm looking at a statement of defendant on plea of guilty to 1 count of operating a motor vehicle without ignition interlock. Plea form references a dismissal of the DWS third charge that was issued along with it. Have you gone over the plea form with Mr. Haverko? And if you had any questions at all about what it meant to plead to a criminal charge, were your questions answered? If I accept the plea, maximum sentence for this would be up to 364 days in jail and up to a $5,000 fine, which I'd be free to impose regardless of what's recommended. Likewise, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. And with that in mind, as to 1 count of operating a motor vehicle without ignition interlock within the city of Yelm on June 24th, 2024, how do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. Mr. Haverko, anything further with regard to?
Nothing to add, Your Honor. Ask court to call the recommendation.
Mr. Ratfield, anything to add to the recommendation? Ms. Rostran, you can tell me anything you wish. If you want to, you don't have to tell me anything. I'm going to follow the recommendation, 364 days, all suspended. Only condition is law-abiding behavior. Stay out of trouble. These requirements with regard to your license, with good driving, they go away after a while. That makes life much, much easier for you. If there is an issue with your license, I urge you to get it reinstated as soon as you possibly can. We live in a world where you pretty much have to be able to drive. Recommendation, of course, 364, 250. The fine is the least important thing to me. If you have trouble making the fine payments, let us know. We can certainly deal with that. Any questions at all?
Before you go, let's sign the judgment.
takes a moment, but I am now electronically signing the judgment and sentence. Ma'am, what I want you to do is go to the counter outside the courtroom to your left, get a copy of the paperwork, look it over. You have Mr. Averco's number. Give him a call if you have any questions. Good luck to you. Take care of yourself.
I need to speak a little.
Mr. Reed, how are you? We certainly can. Absolutely. Absolutely, we can do. Sure. That's on Barbara.
Mr. Ray Bellman, he's got a couple of matters on today on the 1 o'clock calendar. So,
Docket numbers 32 and 33. Good morning. That's here a little early, but hey, as long as you're here early, we may as well take care of your matter now. What? For the record, full name Sean, middle initial C, Ray Bauman. Mr. Bauman, Ray Bauman, you're here on two matters. The first alleges that on or about September 11th, 2024, you committed the offense of criminal trespass, second degree. The second charge alleges that on or about September 16, 2024, you committed the offense of disorderly conduct. Each of those is a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or $1,000 fine. Based on your financial situation, I'm going to appoint Mr. Haverco to represent you on these matters as well.
stipulate probable cause, Your Honor, on both matters. Ask court to enter not guilty, please.
Plea if not guilty will be noted and entered. Mr. Ray Bauman, we're going to give you a pretrial date. I want you to stay in touch with, do you have a phone number you can give Mr. Haverco? But stay in touch and make sure you're back here on the court date.
It's work. There you go. It's all right. No, it's good.
Mr. Ray Bauman, it's going to take me a moment to get to it here, but I will very shortly. What I want you to do is get a copy of the today's order at the window. It'll have the court date on it, and make sure you're back here on that date, okay?
Yeah, just go see the clerk to get your paperwork before you go.
Mr. Ray Bauman, thank you for appearing, even if it was a little bit earlier than usual, but you take care of yourself, okay?
Same as to Mr. Talbot Riddall. He's number 34 on the arraignment calendar. He's here as well.
You need a moment to talk to Mr.
No,
Riddall?
it's just on for arraignment.
Okay.
Where do you go? Mr. Talbot, you can just take care of your arraignment today?
Mr. Riddall, good morning.
Mr.
How are you?
Riddall. This is Talbot Riddall.
Yeah, oh, yes. Mr. Riddall and I know each other. That's why I said good morning to him. For the record, full name Talbot Harold Riddall. Mr. Riddall, the citation alleges that on or about May 13th of 2024, you committed the offense of failing to obey lawful direction of a police officer. Misdemeanor, the maximum penalty on conviction would be 90 days and or 1,000. I'm going to appoint Mr. Haverco to represent you in this matter. Pardon? That's now, this is an arraignment. It's all you do is plead right now. Guilty or not guilty.
You want to represent yourself?
That's a plea of not guilty. I'll recognize it as such. We'll set it for a pretrial hearing. I'll appoint Mr. Haverco as standby representation to answer any questions you might have. You might have some law questions or want to discuss the matter with him.
You have a phone?
You're entitled to represent yourself, but might be a good idea to have a little help just in case you need it. That's all.
You have a phone? Okay.
I'm indigent and homeless. I'm being.
Sorry to hear that. I'm sorry to hear that.
Sign right here. Oh. Okay.
That's what I want you to do. I'll sign an order resetting the matter to October 24th. I'm doing that right now as we speak. I want you to get a copy of that at the window before you leave and look it over and just the date and the time will be on that October 24th at 11. You don't have to write it down. It's going to be on that paper, Mr. Riddall, but yeah.
Where would I be able to file standing and?
File what now? You, any paperwork you want to file, you can file with the court, yes. Okay, Mr. Riddall, I'm signing that now, I think. That's, I hope you're doing better. I hope everything's. Pardon? Hey, well, Mr. Riddall, you take care of yourself and thank you for showing up.
Yes, sir.
Don't forget to stop at the window. Back on record for the morning pretrials.
Thank you.
Mr. Reed, good morning.
Okay. Mhm. Okay, parties have reached an agreement, as part of a stipulated order of continuance on the drug-related charges ending in, case number 740. The 3 drug charges are to be placed on a stipulated order of continuance for 12 months on this condition that he not have new criminal law violations and pay a $250 court fee, at the end of which time it can be dismissed, and also incorporated into the same agreement today, or should be, the suspended driving third-degree case is to be dismissed today.
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 Okay. Got it.
Yeah.
Mr. Reed, for the record, Paul Edward Reed is your full name, is it not? That's it. You disagree at all with anything Mr. Havercoat just said? You've got an SOC here, and what that means is, stay out of trouble, charge will go away, it'll be dismissed. Now, to get the agreement, you've given up your right to go to trial, et cetera, et cetera, et cetera. If there's a violation, the city proves that, then please stay out of trouble. We'll have a hearing based on the police reports, and that'll result probably in convictions, which could result in significant jail time. But hey, what I'd really like to see is for you to get the situation, controlled substance, get that under control. The driving license suspended, revoked third is dismissed, effective now. Conditions of release of this SOC are very simple. Stay out of trouble. $250. That's not important to me. It's part of the deal, but $25 a month, and it's just mostly stay out of trouble. That's a lot of ups and downs in life for all of us, but it seems like there's quite a few more for you for some reason. You do great for a while and don't see it for a while, but then that's things go south. But hey, like I've said many times, it's not how many times you fall down, it's how many times you get back up having fallen down. Mr. Reed, I'm signing off on the agreement. I want you to get a copy of it at the window, look it over carefully. You've been patiently sitting here for a long time. You might want to go to someplace a little quieter than here to look it over. But I'm going to wish you the best of luck. Signing it now.
Yeah, just before you go to the clerk's window and she'll print out copies of your paperwork today.
You take care of yourself.
Mr. Jones?
Mr. Jones, good morning.
So this is Thomas Paul Jones matter comes before the court as item number 5, pretrial hearing on the 11 o'clock calendar for the charge of suspended driving third degree, ignition interlock device violation. I was meeting with Mr. Jones, and we had kind of an amusing conversation. He said, well, gosh, we've been doing this a while, so would the city consider allowing me to plead to the suspended driving third degree case and dismiss the interlock? So I spoke with the city and they said yes, on the condition that, and Mr. Jones agrees. So the recommendation would be, again, on plea to the suspended third, city would move to dismiss the interlock violation. He agrees to do 1 day in jail within 60 days, and the city will not ask for a fine. So essentially, kind of like doing 1 day in jail in lieu of any money, and the interlock goes away. So I think Mr. Jones is happy about that.
Good morning, sir. For the record, is your full name Thomas Paul Jones? Mr. Jones, I'm looking at a statement of defendant on one plead guilty to 1 count of driving license suspended revoked 3rd degree. Also references a dismissal of the ignition interlock charge. Is that your intent? Enter a plea to DOS 3rd? Have you gone over the plea process with Mr. Aberco? And if you had any questions about what it meant to plead to a criminal charge, were your questions answered? Yep.
You're pleading guilty to the suspended 1 day in jail. Right? Yeah. Okay.
No,
That's
the
what he
plea, that's a DWS 3rd, maximum for that is 90 days and or 1,000. I'd be free to impose that regardless of what's recommended. And if I accept the plea, you give up the rights contained in paragraph 5. No trial, no appeal, simply a sentencing. And with that, I'll ask you as to 1 count of driving a license suspended or revoked in the 3rd degree within Yelm on August 6, 2024. How do you plead, guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? Find the plea to be freely, knowingly, and voluntarily made. Your statement in paragraph 11 does satisfy the factual elements. Heard the recommendation, Mr. Aberco, anything to add to that?
Oh, nothing to add, just, that's what the city proposed and Mr. Jones thought it was appealing, so it's agreed.
Anything to add from the city? Mr. Jones, you have a right to tell me anything you wish. I've heard the recommendation. If you want to add anything to that, now's the time. You don't have to say anything if you don't want to. Is there a bus or anything or? Oh, man. Oh, wow, yeah. Yeah, and that is not the safest road beyond.
Yeah.
Any way of reinstating your license? Any way of doing that, you think? It's usually involves money. Oh. Financial responsibility, yeah. Well, maybe you ought to talk to a lawyer about that at some point. That's they're more than one path through the forest. I'm gonna follow the recommendation here. 90, 89, serve 1, call it good. Good food at the jail, I guess. I'm hoping it still is.
I didn't think to ask the city of this, and it's not a big point, but would the city have any objection to inserting into the order that once he serves a day in jail, the case can be closed then? Okay.
Sorted.
Okay. Thank you. No, you just, they'll be notified of the jail and your cases will be closed. Yep.
Jones, in order to serve the 1 day, you'll need a copy of the judgment and sentence to take to the Nisqually jail with you. And you get a copy of that at the window outside the courtroom. I'm going to wish you the best of luck. You take care of yourself. And again, at some time in the future, I'd like to see you get relicensed. But yeah, that's the trouble with where you're residing. The reality is, unless you have a magic carpet or something, hitchhiking is not the way to go. That's the spirit. I'd like to see that. Good luck to you, man. Take care of yourself.
Tammy Kitchen, or excuse me, Nicole Kitchen.
Good morning.
Sign right here. So this is Nicole Kitchen. Matter comes on for pretrial hearing on a theft charge, and parties have reached an agreement. She doesn't have any prior thefts. The agreement is a 12-month stipulated order of continuance on the condition she not commit any new criminal law violations, pay a $250 court fee, at the end of which time then the city, as part of its agreement, would move to dismiss.
Agreed? Good morning, ma'am. For the record, is your full name Nicole Ray Kitchen? Couldn't remember the middle name. Yep, Mr. Everco just outlined the specifics of a SOC, stipulated order of continuance. Contract, you fulfill your side of it, city dismisses the charge. If you violate the agreement, the city proves that. We'll have a hearing based on the police reports. That would result almost certainly in a conviction for theft in the 3rd degree. Don't want to go there. The rules, what you're agreeing to here are pretty simple. That's 1, stay out of trouble, pay. 2, pay $250 by way of costs. I would get that taken care of as soon as you can. I'm hoping that we can simply close the file, dismiss the case without any further hearings once you fulfill. Learn from the situation. Don't repeat it. We all make mistakes. We're all human. We have to learn and repeat. Ms. Kitchen, good luck to you. You take care. I signed off on the agreement. Get a copy of it at the window outside the courtroom to your left. Look it over carefully. Any questions at all? Give Mr. Everco a call. Any questions of me? Good luck to you. Take care.
Yeah, yeah, well. And I'm ready to do the FTAs when you are, Judge.
Let's run them up.
Okay.
Going back to page 1. That's docket number 4. Tim Higgins is the one that did not appear. City have any?
Yeah.
So ordered. How about Victor Messias Perez? Oh, that's right. That's, I'm sorry. Sometimes my note keeping. How about Daryl Turner? DT. Seahawks had a wide receiver of that name a number of years ago. DT. His nickname was Deep Threat after his, he was one of those speedballs.
Okay.
Couldn't catch a cold if he tried, but other than that, he was very fast. So do you have a motion on Daryl Turner, docket number 8, page 2? So, yeah, one of these SOCs where no new violations, but no payments either.
See.
Close. I think we have to do a dismissal with that. Yeah. Mr. Lenz did show up. He was hidden.
Right.
Yeah.
Yeah, he showed.
9 o'clock is completely taken care of. If I didn't say so before, docket number 6, page 5. I've signed an order of dismissal at the request of the city in that charge. That takes us to page
8. Oh,
well,
no.
on page 7, just leave the
Right,
warrant in
right.
effect.
Right.
Page 8, Kevin Vingeman,
Yeah.
no surprise.
Yeah, I don't think, last time I spoke with him, I don't think he had a phone.
Probably-
So,
probably
yeah,
so.
so I was expecting him to, I was gonna talk to him at court, so I haven't had any contact.
I thought of holding him for in custody, but knowing that it was at best a coin flip. Right. City wish a warrant, 1,000 cashier. So ordered. Mr. Newcomer setting the criminal trespass. Well, let's move on to page
And then Paul Scott.
9. Paul Harvey.
I guess we're gonna wait because, okay, gotcha, okay.
Again, I thought about keeping him.
Right.
On his new, on the arraignment on the 1 o'clock. We'll hold off on him.
On the 11 o'clock, there's items 1 and 2. It's Carrillo Ortiz. Well, I spoke with the court administrator indicating that it looked like Mr. Mould, as court certified interpreter, wouldn't be able to help in this case because Mr. Mould told me that that is actually not Spanish. It's a different indigenous language called Northern Mam or Mom. And
Oh,
yeah,
and
it's, yeah, I looked it up on the internet. It's actually a thing. So.
Hmong?
Is,
Spelled Hmong, I believe.
could be.
I think that's a Southeast Asian.
No, well, it's part of, it's a language spoken in parts of Guatemala
Oh, okay.
and, parts of
didn't know
southern
that.
Mexico. It's like, yeah. So, the Madam Clerk called his
Language line.
number to try to reach him to find out, you know, does he need a mom interpreter? Because she looked up one of his other cases in another court, and he did have a mom interpreter in that other court, but she did not, as far as my recollection is, she did not get a response. There was no picking of the call, so she never spoke with him. And I haven't had any contact with him either, so I don't know of his whereabouts.
Well, yeah, it's Mom, Hman, Northern.
Yeah,
Yeah. Well, I think the best we can do is, I think reset it to the next available date, notice to him, and let, Madam Clerk, work on the interpreter issue, reset with notice.
she did give me information that we may, I'm not sure, but the only resource for us might be my use of, I guess it's the language interpreter line or something like that.
Oh yeah,
Yeah,
there's a
yeah.
language line. I
So-
once had an obscure African language that I'd never heard of, for in a Tacoma case I defended. And they came up with an interpreter.
On the 11 o'clock, let's see, on regarding Nicole Schubert, I called the number that she had given me for arraignment. I called her on 9/22, so a few days ago. It appeared to be a good number. She has not contacted me back, so I've not heard back from her. I don't have any information.
Now, who's this, Nicole?
This is Nicole Schubert.
Schubert.
Yeah.
Huh. Too many Nicoles. So ordered. And of course, Robert Trevino.
I also called his number, and I think it was a good number. It seemed to be. I called on 9/22. I both left a message, a voice message, and I also sent a text. I believe it was a cell number. I didn't get a bounce back, so I did also send a text letting him know who I am, why I was trying to reach him, and please contact me. I haven't had any return contact.
I think DUI, I think 25. Okay. 2,500. And of course, he's got the obstructing charge on the next page. We need a separate warrant on that. Huh? 1K. Well, see if Mr. Paul Harvey Scott shows up at 1. We've already taken care of. Gonna call one matter out of order. That would be docket number 5. Yelm versus Lily Bonner. Ms. Bonner, I believe you're in the courtroom. If you'd step forward and have a seat at the council table, we're going to take your matter at this time. Ms. McLaughlin?
Yes, Your Honor, I'm present.
Ms. Bonner's in the courtroom and seated at the council table. Good afternoon, ma'am. Your full name is Lily Marlene Bonner. Citation alleges on or about September 24th, 2024. You committed the offense of driving while under the influence of intoxicants, a gross misdemeanor. The maximum penalty upon conviction would be 364 days in jail and or a $5,000 fine. At this point, I'm going to turn to your attorney, who's here by way of Zoom, to enter a plea on your behalf. Mr. McLaughlin?
And for the record, Your Honor, Martha McLaughlin on behalf of Lily Bonner. I'm standing in for attorney of record Barbara Bowden. Your Honor, we did review defendant's rights at arraignment. She signed those. I filed those in the O courts. I didn't have a complaint, but I did discuss with her the maximums and mandatory minimums for the DUI charge, and she will be entering a plea today of not guilty.
Ms. Bonner, a plea of not guilty preserves your rights. We're going to set the matter for a pretrial conference with your attorney at this point. Ms. McLaughlin, we have October 10th, October 24th, November 7th, and private attorney matters are always handled at 9 o'clock.
Okay, so that you said the 24th or November 7th.
In October,
I think November 7th, Your Honor,
November
if that
7th.
works for my client.
Ms. Bonner, that works for you? Any conditions of release earlier set? Mr. McLaughlin, that included ignition interlock, and we just received proof of that having been filed. So
Yes, Your Honor, thank you.
The earlier set remain in effect. Don't drive unless licensed and insured. Don't drink and drive at all. Any officer asks you to take a breathalyzer, you're to do so. Stay in touch with your attorney and appear for court as directed. Any question at all, Ms. Bonner? Mr. McLaughlin, anything further?
No, thank you, Your Honor.
I'll sign an order on today's hearing. Your client can pick one up at the counter before she leaves, and we'll be sending your office one.
Thank you very much. And thank you for taking us early.
Take care.
Bye-bye.
Bonner, I'm setting the pretrial order, electronically signing it at this time. What I want you to do is get a copy of the order at the window and I apologize maybe for the confusion this morning. That's such things as that always happen, but no real harm done. We'll see you back here in November. Stay in touch with your attorney. Any questions at all? Don't forget to get a copy of today's order. Thank you for appearing twice. Going to call the rest of the 1 o'clock calendar. Today's your first appearance after receiving a criminal citation. Before I call you up one at a time, I need to advise you of a couple of things. One, you have a right to have a lawyer represent you at all stages of any criminal proceeding. If you're indigent, I would appoint Mr. Haverco to represent you throughout the course of your case if you require his services and ask for them. He will, in any event, enter a plea on your behalf at this time, regardless of your financial status. The plea at this time is invariably not guilty. That's not any great statement about the case, but it does preserve your rights pending a pretrial. The purpose of that being to discuss the matter with an attorney, and he in turn with the state's or city's representative, determine whether or not the case can be resolved by agreement. If it can be, that is put on the record. If it cannot be, you have a right to a public and speedy jury trial in the county where the offense was allegedly committed. If you have any question at all about your rights or the procedures here, ask either Mr. Haverco or myself. Start with Sean Avery Alston. Number of people will not appear. At the end of today's calendar, I'll review the cases, and if there was probable cause for the issuance of the ticket in the first place, or it'll be issued for the arrest of the non-appearing person. If you at least save yourself a warrant for your arrest by just simply showing up, and for that, I want to thank you. How about Sarah Winter Barrett? Again, does not answer. Diana Bain is not, we'll call that again, I think is in another jurisdiction. Andrew Christopher Cahill Williams. Good afternoon, sir. For the record, I have to verify that your full name is Andrew Christopher Cahill Williams. Mr. Cahill Williams, you're here for arraignment on a new charge of protection order violation alleged to have occurred on September 12th, 2024. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Havico to represent you in that matter as well, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty preserves your rights. We'll now set the matter for a pretrial. Mr. Cahill Williams, what I'm going to do is calendar all your matters on for a new compliance hearing on the previous cases and as well as a pretrial on the new case. I want to remind you that until it's modified or rescinded, an order of no contact remains in effect and valid with potential bad consequences should you be found to be in violation.
Your
New
Honor,
hearing will be on October 24th. Mr. Haverko, any questions?
I was going to ask you, was Your Honor willing to address the issue of the no contact order today? I believe he submitted to the court a certificate of completion of his DV-related treatment program through the United States Army, and I want to know if Your Honor would.
I would prefer to hear from Haley DeVille, which is the protected party in this matter. Is she available by any chance? I don't see her in the courtroom.
We could ask her to come up here. She has the baby.
Pardon?
She has the baby. We could ask her to come up here.
How long would it take her to get? Like, how long? Give her a call.
What? I'll take that matter up at the end of the calendar if you wish. That'll take longer than 20 minutes, I'm quite sure, but I would be willing to address that today. But I would want to hear from her first.
And then just wait. Give her a call.
In the meantime, sir, if you would go to the window, get a copy of today's order. It'll have the necessary information on it. Jessica Davis in the courtroom. Jessica Davis. Jeffrey Flowers. How about Mark Frost? Mr. Frost, come on up and have a seat if you would. Full name Mark, middle initial A, Frost. Mr. Frost, you were cited for the criminal offense of no valid operator's license without identification. That's a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. The city has a standing motion. The prosecutor was called away, cannot be here today, but the charge is amended to no valid operator's license with identification. The difference is that's a civil infraction. No jail time. If you admit the infraction, I'll impose a $150 fine. If you deny that you committed the infraction, we can set it for a contested hearing, and that'll be at the next court date, October 10th. Any question about anything I just said? Pardon? Whatever happens today isn't going to have any effect on your license. It won't suspend it or. But if you admit that you didn't have your license on your person to show the officer on the time, I'll fine you $150. If you deny that that happened, we'll set it for a hearing.
We set it for a hearing?
We certainly can. The burden is on the city to prove that you violated the ordinance You deny that you committed the infraction. Pardon? Hey, that changes things. Now, you are entitled to contest it if you don't think you did anything wrong, but you can take care of the matter today by admitting it. Is that now what you want to do? Yes. I'll do exactly what I said, $150 fine. You can pay that at $25 a month. Do you have a valid license or? That's but you are working on it. That's the important thing. I want you to get your license as soon as you can. We live in a world where you pretty much have to be able to drive. That's so don't give up on that. Whatever it takes to get relicensed, I'm going to ask you to do that. That's part of the drill. You pass the test, get your license back, and be good to go. That's, yeah, they reinstate you once you pay the fee. It's, yeah. We're preparing an order here with the help of Madam Clerk that is just about ready to go. Now, what I want you to do is get a copy of today's order at the window outside the courtroom and to your left, Mr. Frost. Look it over carefully. If you have trouble making the payments, I want you to let us know, okay? Now, I'd rather have you spend your money getting reinstated. If you need a continuance or more time to pay the fine imposed here, I'll gladly give you the time, but let us know, okay? One way or the other. Great. Now signing the order. Mr. Frost, that concludes the hearing. Don't forget to get a copy of the order. Okay. Thank you for appearing and good luck. Donald Gott. Good afternoon, sir. Full name Donald John Gott. Mr. Gott, you were cited with something very similar. Driving a license suspended or revoked, 3rd degree. Now that charge is what they call a simple misdemeanor. Same offense. There's the same penalties, 90 days in jail and a $1,000 fine. And if you would mute your cell phones. Now the city has a standing motion in your case as well. The charge is amended to no valid operator's license on your person. The difference is that is a civil infraction and not a criminal offense. If you admit the infraction, I'll assess a $150 fine. Mr. Gott, if you deny the infraction, we can set it for a contested hearing. Now, any questions about what I just said? You can admit it and I'll impose a $150 fine, or you can deny it. You did anything wrong and I'll set it for a hearing. What do you wish to do? Admit or deny? I'll assess the $150 fine. And now the important thing is, I'd like to see you get reinstated. I went down yesterday. That's the first step. Wonderful. It's paperwork and money. It's okay. I'm signing an order to that effect. And again, I'm going to tell you the same thing. I'd rather have you spend your money on getting reinstated than paying the court. So if gets difficult to make the payments and reinstate, let us know and we'll figure it out. Okay. Mr. Gott, good luck getting reinstated. Any questions at all? Can I make payments on? You can make payments on this. Yes, $25 a month. And that'll be in the order that you're going to get a copy of. Good luck getting reinstated, Mr. Gott. You take care of yourself. Don't forget to get a copy of the order. Out the window and the window to your left. Dorino Graves in the courtroom? Dorino Graves. How about Jessica Hayes? Getting no answer. Charlie Jackson. Adam Jones. Good afternoon, sir. Full name Adam Gregory Jones. Mr. Jones, the citation I have alleges that on or about September 22nd, 2024, you committed the offense of DUI, driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you for purposes of this hearing. He'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
As I indicated, Mr. Jones, plea of not guilty preserves your rights. Mr. Jones, conditions of release are don't drive unless licensed and insured, don't drink and drive at all. Any officer asks you to take a breathalyzer, appear back here for court when directed. That's October 24th. And stay in touch with Mr. Haverco. His contact information is going to be in the order, and I want you to get a copy of today's order at the window outside and to the left.
Okay.
Any questions at all?
Do I need to contact someone?
Oh, sure. You may as well let him know. Yes. And I may say that for the benefit of anybody, you're entitled to hire a lawyer if you wish, and are able to do so. Just simply let us know. And your attorney, if you do hire, he'll file the appropriate notice of appearance, and he may want to contact Mr. Haverco. That's easily done. Any more questions? Take care and good luck. That's it. Christopher Kenny. Good afternoon, sir. For the record, Christopher Freedom Kenny, I believe. Mr. Kenny, citation alleges that on or about September 15, 2024, you committed the violation of violating the terms and conditions of a protection order. There's 2 counts. Each count would bear jail time of up to 364 days in jail and up to a $5,000 fine, this being what they call a gross misdemeanor. I'll appoint Mr. Haverco to represent you in this matter. He will enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Kenny, that plea preserves your rights. Kenny, I signed the today's order. You'll need to get a copy of that at the window outside the courtroom. Conditions of release, law-abiding behavior that would include abiding by any protection order, the orders that are in effect. Appear back here for court as directed, and stay in touch with Mr. Haverco. Okay. Any questions? Take care. Good luck. Joshua Robert Laberton. Good afternoon, sir. Full name Joshua Robert Laberton. Citation alleges that on or about September 6, 2024, you violated the terms and conditions of a protection order, 3 counts. Each of those counts bears a possibility of jail time of up to 364 days and a fine of up to $5,000. I'll appoint Mr. Averco to enter a plea on your behalf, Mr. Leverton, and he'll do so at this time.
Stipulate probable cause, Your Honor. Ask the court to enter not guilty, please.
October 24th will be your pretrial. Conditions of release, of course, are law-abiding behavior, which includes abiding by any protection orders that happen to be in effect at the time. Appear back here for court on October 24th. Stay in contact with Mr. Haverco. I'm not going to inquire into anybody's financial circumstances today, but if you are indigent, he'll represent you throughout the course of your matter.
Yeah, before you go, just go up to the clerk's window and she'll print your paperwork with the dates and everything. Got it, yeah.
Mr. Leverton, that concludes today's hearing. I've signed the order. Don't forget to get a copy of it at the window outside the courtroom and to your left. Take care of yourself. Thank you. Next would be Janie Ann Labrum. Good afternoon, ma'am.
Okay.
Full name, Jamie Ann Labrum. That's it. Ms. Labrum, the citation alleges that on or about September 18th, 2024, you committed the offense of driving while under the influence of intoxicants. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time. Usually somebody that's post substantial bail, as you have in this matter, is not indigent. Are you asking for an indigency status? Relative? I'll leave that up to discussions between you and Mr. Haverco.
Stipulate to probable cause as court to enter not guilty plea.
That was, I'm going to order that you get ignition interlock. You were cited for DUI. Given your history, I'm going to order that you install ignition interlock if you haven't already.
Yeah, she has proof, so she can probably show this proof to the clerk
If she would,
before she leaves. Yeah.
you're going to get a copy of today's order by going to the window. What I want you to do is make sure the deputy gets a copy of your proof. Any questions at all? Conditions of release are law-abiding behavior. Don't drive unless licensed and insured. Don't drink and drive at all. In fact, I'm also going to order that you don't drink at all. Any question at all? Please get a copy of today's order at the counter and be back here on October 24th. Samantha Lehman. Good afternoon, ma'am. Full name, Samantha Grace Lehman. Ms. Lehman, I have two matters here. It's first alleged that on or about August 27th, 2024, you committed the offenses of driving a license suspended, revoked, third degree. You're also given a citation for the same thing on September 3rd, 2024. Each of those charges is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail for each. and a $1,000 fine for each. The city is not making the standard motion in this case, so I will appoint Mr. Havercoat to enter a plea on your behalf and represent you in these matters. Mr. Havercoat?
Would stipulate probable cause, ask the court to enter not guilty pleas on both cases.
Sleeman, a plea of not guilty has been entered on your behalf. Now, that's conditions of release are very simple. Law-abiding behavior that would include don't drive unless licensed and insured. It's a relatively small area here. The members of the police department, they get very familiar very quickly with the people that are driving. So that's a good idea to just stay off the road. Do not drive unless you're relicensed. And that really is the only thing we're really interested in here is people getting relicensed. Setting a pretrial for October 24th.
Why don't you write it down?
Sleeman, any questions? Concludes the hearing. Again, make sure you get a copy of today's hearing at the window. Good luck to you. Oh. Chelsea Rose McCabe. Good afternoon, ma'am. Full name, Chelsea Rose McCabe. Did I pronounce that right? Citation alleges in honor about July 4th, 2024, you committed the offense of criminal trespass first degree. That is a gross misdemeanor. The maximum penalty and conviction to be 364 days in jail and or a $5,000 fine. Ms. McCabe, I'll appoint Mr. Havercoat to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty, as I indicated earlier, preserve your rights. Okay, thank you for appearing. You take care. And don't forget to get a copy of the today's order. Take care. And you as well. How about Jessica McDonald? Good afternoon, ma'am. Full name Jessica Nicole McDonald. Ms. McDonald, the citation I have alleges that on or about September 12th, 2024, you committed the offense of assault in the 4th degree. That charge is gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I appoint Mr. Havercoat to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Ms. McDonald, a plea of not guilty does preserve your rights. No contact.
3218.
And Ms. McDonald, the condition of release is law-abiding behavior, and that would include anything involving domestic situations. And also, I'm in order that you have no contact with Mr. Michael Lohman pending any further.
She's indicating that is he a parent also? Okay. Would the court be, well, apparently, The victim in the case is also the father of the children. The children are with the dad at the moment. It's a long-term relationship. I guess they're separating. Would the court be willing to just impose a no hostile contact condition as part of just the conditions of release and not a separate no contact order?
Of course, the no contact order does not cover have anything to do with the children. Does he have custody of the children or is shared custody? You have separate residences? I'm gonna leave the order as it is until we can hear from him. I realize these domestic situations are a little complicated and there's sometimes a lot more about them that is either known by either the prosecutor, myself, or your own attorney even. I believe the order as it is. And of course, the order does not affect your relationship with your children at all. And I'll revisit your next court date will be October 24th, and we'll revisit the situation then. Or if there's some sort of an emergency, Mr. Haverco can get you back into court earlier. Donald, I'm signing the order as we speak. And get a copy of that at the window and make sure Mr. Haverco has your contact information. His information will be on the order that you're going to be getting. So good luck to you and take care. Eric Daniel Meneses. I'm pretty sure I mispronounced that, and for that I apologize, sir. Is it Eric Benil? No. How do you, Menezes? Is that an unusual citation here I don't see very often? You were cited for having a suspended registration. I take it that's a misdemeanor? I'm exchanging puzzled looks with Mr. Haverco here. In any event, it looks like at the very worst, it's a misdemeanor, the maximum penalty being 90 days in jail and or a $1,000 fine. And I'm going to take a look at the statute and the case.
The fact that there's an infraction disposition of courts, is that an indication the city might have been amended?
I don't remember ever seeing this charge before. I think since Mr. Atfield isn't here, I'm inclined to just have you enter a plea on behalf of the defendant, and we'll.
Okay. Stipulate to probable cause, Your Honor, and support enter a not guilty plea.
In any event,
Can't deal with that today.
it's going to take some research.
Okay.
October 24th. The important thing here, until the dust settles and we figure out what exactly is going on, that's your rights are protected and preserved. Resetting the matter to October 24th. Conditions of release are just law-abiding behavior, period. But it says, good luck. You take care. We'll see you back here October 24th. Any questions? That's all matter we should address later. Not at this time. But thank you for appearing. Take care. Ely Tucker Payne. Does not answer. We'll come back to that matter. How about William Tanner Reeves? Good afternoon, sir. Full name, William Tanner Reeves. Mr. Reeves, you, looks like you also were cited with DWS 3rd degree. The criminal offense in the city, this motion does apply to you at this time. The charge is now the civil infraction of no valid operator's license on your person. If you admit the infraction, I'll assess a $150 fine. If you deny that you committed the infraction, we can set it for a contested hearing. Now, that might be a little bit too much all at one time. Any questions about anything I just said? Right. What would you like to do? Admit the infraction or deny it? Okay. I'll assess 150, and of course, what I really want to know is what it's going to take to you get your license reinstated. You know that? I'm going to urge you to do whatever it takes to get your license back in shape. I'm signing an order, setting the fine at 150. And again, if there's an issue, pain, money's always involved in it. If I'd rather have you spending your money on reinstatement than on a fine here. So if that's if this hangs you up a little bit, let us know. We'll figure it out. Mr. Reeves, good luck. You take care. Get a copy of today's order at the window and be good to yourself. Next would be Daryl Ray Russell. Mr. Russell, how are you? Not bad at all. And again, for the record, confirm your full name is Daryl Ray Russell. Yeah. Mr. Russell, you were cited with two things, DWS 3rd and failure to transfer title within 45 days. Now, the city routinely and does so move here to amend that to no valid operator's license and expired tabs on the transfer title. Those are infractions. If you admit them, I didn't even have to finish what I was going to say. Mr. Russell, you making any progress in getting reinstated? That I'm really glad to hear. That's it'll be 150 on one and 150 on the other, 25 a month, and it's just adding up. Yeah, let's stay off the road and until you chip away and get your license reinstated and don't have to bother coming to court all the time. Mr. Russell, I'm signing the order on today's hearing. What I want you to do is get a copy of that at the window. And again, good luck in getting reinstatement. Don't give up on it. It's I realize it's always a matter of time and money. But good luck to you. Paul Harvey Scott is not here. How about Nicole Shoemaker? Does not answer. Ham Sikhath. I'm going to come back to that matter later. Kayla Marie Turo. Good afternoon, ma'am. For the record, full name Kayla Marie Turo. Citation alleges in honor about September 15th, 2024, you committed the offense of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time, and he's going to represent you throughout the course of the day.
I think Your Honor would stipulate to probable cause, ask the clerk to enter not guilty plea.
Mr. Turo, that plea preserves your rights. It'd be my turn. Excuse me, I'm now signing today's order. Mr. Turo, what I want you to do is go to the window, get a copy of it. Stay in touch with Mr. Haverco, and we'll see you back here on the date of your pretrial, okay? Any questions at all? Thank you for your patience. Take care. How about Jeremy James Walling? Full name, Jeremy James Walling. Mr. Walling, you likewise are in the same position as some other cases that were heard earlier. Cited for DWS 3rd degree, the city's amending that to NVOL 2nd degree. Again, you probably know by now, if you've been paying any attention, it looks like you were, you could admit it and take a $150 fine or deny it and get a contested hearing. Any question about what's going on here?
So, I will essentially have to admit it, but I'm going to see if we would have.
Well, if you're not guilty, I'm not gonna find you. I'm not gonna find you that admitted anything.
Yeah, well, you want me to bring you the?
Well, at this hearing, what you would ordinarily do is either, admit you committed the infraction, and it doesn't sound like you're doing that, or deny that you committed the infraction, and then we set it for a contested hearing, and that would be October 10th. Is that what you would like to do? But yeah, and I've got another calendar coming up here in a while. I don't like to keep people waiting unnecessarily. Would you like to set it for a contested hearing on the?
Can I admit and still,
It's, well, kind of 6 of one, half a dozen of the other, was it? Yeah, I've got to do,
sorry.
well, that's why I'm trying to, I always ask, do you have any questions? Yes, to me and to Mr. Haverco, it's something we just live with, but I have to remember sometimes, and sometimes I fail to do so, that sometimes you're venturing into strange waters and unknown land, so to speak. But yeah.
If I do, you perhaps know.
It depends on what you have to do, why it's reinstated, and who and why it's. So usually, it takes time to do that. And then again, that's the most important thing to me is that you get reinstated. But where you start with is the Department of Licensing. And if it's most ordinarily, it's unpaid tickets.
Yeah, I do have information on.
Oh boy.
The situation for
That really is not a matter for me. That's a matter with the Department of Licensing. That's, whether they did, should, or should not have, that's not anything I'm gonna, adjudicate or rule on. That's beyond I gotta stay in my own lane. It's the financial responsibility, yes, that's kind of a complicated area. I'm not gonna go into it. It's yeah, ordinarily, if you're uninsured and you get into an accident, you're responsible financially for it, and they can yank your license. Now, whether it's your car or not, the circumstances under which it was loaned out, was it stolen, all that is something between you and the Department of Licensing. I can't address that in this court. It's probably, if you want to admit it, I'll assess 150 and let you, and you might want to talk to a lawyer about your situation. That's, again, that's a financial responsibility law is something I've had to deal with as a private attorney many, many times on behalf of many, many clients. And there's not a one size fits all answer to them. Mr. Haverko may disagree with me, but hey, what do you want to do? Let's you just want to take the fine and because yeah, if we did go to hearing on it, the only question I would have is was your license suspended by the Department of Licensing on the date you were issued, and were you driving, indeed driving, and it wasn't a mistaken identity? That's what I would rule on, not whether or not the department had the authority here or properly suspended your license. I can't get into that. Again, as a technical matter, you don't plead guilty or not guilty to a civil infraction. You admit it or deny it. A crime is something you plead guilty or not guilty to. Just, but hey, no problem. I hear the same thing all the time, and it's, maybe I'm full of useless information. Okay, and sometimes I impart it without being asked. But Mr. Wallen, I'm going to ask you, maybe talk to a lawyer about your situation there with the, I don't know how much money's involved. I've seen, $2,000-3,000. I've seen these things where it's $200,000-300,000. So what I would do is, I'd maybe talk to a lawyer. It might be worth the consultation fee, I think. I'm signing an order to that effect. That order will be available for your copy at the counter. There we go. Good luck getting things resolved with the Department of Licensing. You take care of yourself. Sorry. Hey, thank you for your patience. Robert Williams does not answer. Sir, you were, what now? Mr. Williams, we can call your matter now if you want. I'm sorry, I did not see you over there. Robert Colton Williams. Mr. Williams, citation alleges that on or about September 18, 2024, you committed the offense of criminal trespass second degree. You were also cited to be in court on October 10th on a new trespass charge, same thing. I'm going to appoint Mr. Haverko to represent you on both charges, and he'll enter pleas on your behalf with regard to both charges at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Williams, we may not have a cause number on the second charge. Oh, good.
Yeah, it works.
Good. Go ahead. May as well. spinning a little. Sometimes.
Are we gonna do the arraignment on the other one today? Okay. Okay. Oh,
That's
okay.
where,
Gotcha.
Mr. Williams, conditions of release are always law-abiding behavior. Stay out of trouble. Are you okay?
Yeah.
They say the
Just
new one.
disappeared and. In there.
Right, sign one more time.
It's hot. There we go. There we go. It just popped. Mr. Williams, I want you to get a copy of today's order at the window outside the courtroom and to the and to your left. You take care of yourself, all right? And you as well. Thank you.
Mr. On 1 o'clock, item number 1, Sean Alston, he's here. Why don't you come on up? Yeah, why don't you come on up?
Come on up. That's so, well, better late than never. Where you're here. That's the important thing. Full name Sean Avery Alston. Mr. Alston, you recited on September 22nd for driving a license suspended, revoked, 3rd degree. Also cited for failure to transfer title within 45 days. As you know by now, the city usually amends those and will in this case to 2 infractions. 1, no valid operator's license on your person, and 2, expired tabs. If you admit the infraction, it's $150 each. If you deny you committed the infractions, we can set the matter for a pretrial. Any question about anything I've just said? Will do. Let's resolve the matter that way. $150 each. I'm signing a order to that effect. Mr. Alston, that does resolve the matter. You take care of yourself. What I want you to do is you can get a copy of today's order by going to the window outside the courtroom. Have any issue at all making the payments, let us know, okay? All right. Thank you. Good afternoon.
Want to come on up?
Now, let me say that this is, I've dealt with, just a ton of, well, I suppose I should identify yourself for the record. Present in court, in person is Haley Neville. No, I mispronounced your name, Neville. Once again, and you're the protected party in an order of protection. your husband's attorney, did raise the possibility of, amending or changing or withdrawing the order, at some point. Let me say first that the primary concern that I have in these cases is your safety. It would keep me awake at night, and I know judges that are in that position of having made a decision that turned out to be the wrong one. And, including, a friend that, over a prosecutor's objection, led a, drunk driver, out of jail, and who promptly went out and got drunk and killed somebody. So that was, but I'll hear from you on what you want me to do here. That's it. He has a certificate of completion for that. Do you have a safety plan? I'm not asking you for documentation. I just want to make sure that you're aware that, given the history here, and I'll say this in front of, your husband, that you're at risk. The initial offense, if you will, was troubling, and I've seen a lot of these, both as a judge, as a defense lawyer, and as a prosecutor. Against, Mr. Haverko, anything to add?
Pardon, Your Honor?
Anything to say?
Um,
To add?
This case has gone on a long time, and, you know, it would
And
appear
it's
that.
still pending.
It is, and unfortunately, probably only out of financial, circumstantial necessity, they were together. There doesn't appear to have been for some time any hint or sense of any assaultive behavior. I mean, technically, obviously violating a no contact order is defined as domestic violence, but what led to the order in the first place was the assault. It's been a long struggle, but I would say that given that the fact that the defendant has, in light of some difficulty in getting it completed, he did complete his domestic violence treatment program through STOP in connection with the U.S. Army. She's saying she feels like she has a safety plan and has a way of getting herself out of harm's way if something else happens. So I agree with you. There's some risk to it, but I think the fact that we've seen these cases come back through this court for quite some time, and other than the initial allegation, I haven't heard any suggestion that there's been any assaultive behavior. Rather, it's been just the difficulty of living with this order. So I think it's a reasonable request. So I'd ask the court to rescind the no contact order.
In view of the fact that I am mindful that each and every violation, alleged violation of a no contact order, has been of a consensual nature and been for the purposes of, well, in violation of the existing order, but for the purposes of child care. The initial event was troubling in its aspects, and I do have concern for the safety and welfare of the alleged victim. I think, given the circumstances and the totality of them, I'm going to rescind the no contact order. And hope I'm doing the right thing. It's, again, there's nothing certain in life. There's nothing certain in life, and I can't say that, you know, from sitting up here and you down there, that I know either you or your husband, except from what little I can observe. But yeah, I'll sign an order rescinding the no contact. I don't know if we can prepare to do that. Okay. Hold on, hold on. Where is that in the, under the criminal? Okay. Okay, great, great.
Is that-
I gotta
that's
hit the
the-
refresh button.
Mr. Cahill, Williams, you'll need to come up and there's a spot for you to sign on the order too. No, because you're actually not a party. Yeah, go outside. Yep.
Mr. Bill, I'm signing the order at this time. If there was a place on the order for you to sign, I would have you do so, but there is not. But I do want you to be, you know, fully aware of what I'm doing and be fully aware of the risks involved in any human relationship. I can just wish you the best of luck, and don't give up on each other. And yes, and it's a continual process, you know. There is no switch you can flip, no magic pill you can take, and all of a sudden everything's just really okay. It's something you're gonna have to work on together for as long as you're together. Good luck to you both. And again, you can get I signed the order. It's might not be a bad idea if you're out and about to keep a copy of that on you. It's
Yep.
since you inevitably become fairly well known to law enforcement. I'm going to wish you the best of luck, and never forget the lesson that you're always in the process of learning. Take care of each other. Take care of yourselves. Thank you. Brings us a little early to the 2:30. I assume you're here for the 2:30 mitigation. You're waiting for a lawyer, I take it? Okay, and your name is? Mr. Payne, it was one. You're late, but not too late. Let's come on up. How do you pronounce your first name? Ely or Eli? Eli. Is your full name Eli Tucker Payne? Mr. Payne, the citation alleges that on or about September 12, 2024, you committed the offenses of driving license suspended, revoked second degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited for being a driver under the age of 21 in possession or consumption of intoxicants. That is a simple misdemeanor. The maximum penalty on conviction is 90 days in jail and or a $1,000 fine. I don't know why that's what the statute reads, if my memory serves me correctly. I'm going to appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate to probable cause on both matters, ask the court to enter not guilty, please.
Mr. Payne, a plea of not guilty preserves your rights pending a pretrial, which we're going to set in a minute. You did, before I had a chance to talk to you, you did bail out of jail. I don't know what your financial status is. If you're indigent, Mr. Haverhill is going to represent you.
Post it on. Okay.
I might advise you, based on your record, which I'm aware of, there's some judges that would take you into custody right now, and your bail would be around $50,000 or $75,000. You're in the process of, looks like, making a total train wreck of your ability to drive a car. We don't go into that at this time.
Do you have a phone number? Oh. Phone number. That's your. Phone number.
Payne, conditions of release are always law-abiding behavior. That would include, of course, now drinking and driving. And in your case, you're under 21. It's against the law for you to be drinking at all, period. This is, I want you to perhaps discuss with Mr. Havergo the jeopardy you're putting yourself in terms of A, your ability to drive at all, and B, custodial presence for a while. Signing an order on today's hearing. Mr. Payne, what I want you to do is get a copy of that at the window. Stay in touch with Mr. Haverco. Be back here on the 24th.
Yeah.
And absolutely no.
You'll get my information and some paper before you go. So just go see the clerk and I'll print up some stuff for you. Yeah, I'll,
No drinking at all, no drinking, especially no drinking and driving, especially. Good luck to you. Get a copy of today's order and
Sorry,
that's a real good step in the right direction, but it's nothing we need to address right now. I'm going to leave that up to you. Since it's at pretrial, I can't order you to get into treatment. I'm going to leave that up to your own judgment because I have to. If I could order you that, I would at this point, but I can't do that. Mr. Payne, thank you for appearing. You take care of yourself. We'll see you back here on October 24th. And you as well. Take care. And with that, I believe we'll go off record.
it's a wrap.
Gonna go back on record for the 2:30 contested calendar. I believe we have an attorney present by way of Zoom. Good afternoon. I'm going to call the matters of Yelm versus Kevin Vargas Maravilla and Sage Warnes at this time. Good afternoon, counsel.
Good afternoon, Your Honor. Thank you so much. Nice to meet you. I don't think we've met before. My name is Attorney Vinny Rendawa, and I'm counsel for both of the cases you just called.
Okay, and if I tried to mispronounce your last name, I would mispronounce it, and I'm not going to insult you by doing that.
No worries. It looks a little tougher than it is, Your Honor. Rendawa, but no problem. I'm used to it.
Rendawa.
Yes, sir. Thank you.
Mr. Rendawa, I'll entertain any motions you might have in connection with your matters.
Please. Thank you so much, Your Honor. We can proceed alphabetically. These are both at the end of the alphabet, so I do believe Vargas Maravilla would be the first one for us.
Okay, go ahead.
Thank you. And again, good afternoon. I'm asking to waive my client's presence, Your Honor, for purposes of this afternoon hearing. I do have several motions for the court. I will proceed with what I begin are going to be the strongest. And my first motion, Your Honor, would be a motion to exclude and suppress the officer's narrative. This would be pursuant to RCW 5.50010 subsection 3E. After review of his certification portion, Your Honor, it does indicate that it is lacking the agency and or department designation, which is a requirement for that particular statute for admissibility purposes. And under those grounds, we'd like to make a motion to suppress if we may.
Motion granted.
And with that suppression, we'll make a follow-up motion to dismiss for insufficient evidence.
Motion granted.
Thank you, sir.
And send you a copy of the same.
Appreciate it.
My assistant will, my clerk will, without whom nothing gets done. But go ahead.
Definitely. Yeah, no, they are the best. And last but not least, Your Honor, last name Warnes. First name is Sage, and this one is 480-302-793.
Have it in front of me.
Thank you, sir. And I'll just cut to the chase. We have the exact same issue, Your Honor. It's an objection under RCW 550-010 sub 3 sub E. Again, as you can see, there's no agency and or department designation. And under those grounds, we'd like to make a motion to suppress and dismiss.
Motion heard, motion granted.
Thank you, Your Honor. That concludes my matters for you today. I greatly appreciate it. You take care and have a great day.
Hey, you as well. Hey, thank you for appearing. You take care. We'll be sending you. You want us to send a copy to your client as well, or we'll leave that up to you?
I can send that to him. So whatever's easiest for the court. If they just want to send it to me, we'll notify everyone of the results today, and we'll get it taken care of.
Okay, great. Will do.
Thank you, sir. Take care. Bye-bye.
Take care. Be well.
All righty.
Give me a moment to, good. All right, perfect. Good afternoon, Mr. Harbison.
Good afternoon, Your Honor.
Call your matter now. I believe you're here on behalf of Tyron Michael, Mr. Edwards. There's a remaining speeding ticket.
I am, Your Honor. And whenever the court is ready, I can make a preliminary motion.
I assume that, go ahead. I have the ticket in front of me. Go ahead.
Thank you, Your Honor. Your Honor, the officer in this ticket says he was operating the SMD unit on moving mode. And I was looking through the ticket to see if he actually had evidence that his patrol car speedometer was properly calibrated and how that was tested. I don't have that information in his affidavit. That is required pursuant to the Washington State Patrol as far as on these moving tickets. And I would ask the court to suppress the reading and dismiss.
But I'm going to grant the motion. I've reviewed the statement, and that's a motion is well taken.
Thank you, Your Honor.
The motion to dismiss is granted. I'll sign an order to that effect. Mr. Harbison will be mailing you a copy.
Thank you very much. You have a great day.
And you as well. Take care. Ivory. Back on record for the 1 o'clock no shows. Going to page 14 of the docket, the first one I have is Sarah Barrett. Do find probable cause for issuance to her of a citation for refusing to comply with an officer. And apparently she called here asking and 1,000 cash or bond. Low bail. Diana Bain apparently is in custody on a felony. I do find probable cause for a theft, third, and obstructing. 1,000 cash or bond on each to preserve jurisdiction. Next would be Jessica Davis, page 15, docket number 10. Probable cause was found by myself when I talked to her in custody. 1,000 cash or bond. Next would be Jeffrey Flowers, amend DWS to Noval 2 and FTA the same. Dorino Graves, the new charge, docket number 17. I might have Mary Chase involved in that. Find probable cause for protection order violation together with obstructing a law enforcement officer. 1,000 cash or bond. Jessica Hayes, I find probable cause for a theft, third. I cite to her. 1,000 cash or bond. Charlie Jackson, there's a note here, I do find BC, but note to do not issue a warrant if it fails to appear, reset with notice. And boy, that brings page 20, I think. At the 10 a.m. Made a note on the file. That's he did not show probable cause was found. I released him on it on his new disorderly conduct. Just 1,000 cash or bond on each. He assured me he would be here, but no. Nicole Shoemaker, probable cause was previously found when I released her from custody. She's booked in on the charge. Docket number 38, dismiss on my own motion. He was released earlier with a promise to appear, did not appear, warrant reissued. He's been found incompetent by other jurisdiction. And when I spoke to him this time, he was clearly way beyond rationality. Move to dismiss. It will be dismissed. And I think that is it.